Okay, just waiting for the reporter.
Okay, thank you.
I think we're all here. Mr. Cameron, if you put your camera on.
My camera is on.
Okay, we're not, I don't see you. Miss Marion, can you see him?
No, I can't, Judge.
Okay.
Okay. Oh, Lisa is seeing me?
We do not see you, no.
Hold on. Now?
I see him, Your Honor.
Yeah.
Now he went away. Now I see him.
Okay, I see you, yes.
Okay, good.
Okay, Mr. Cosmo, if there's any reason why your hand is raised, you want to say something to the
No,
board?
for me to see you.
No, not this way. You see your hand over there? Your hand is raised.
No, it's, I'm present. How do you take this off? Okay. No.
Okay, great. Okay, so with that on the record, Mr. Kymar, you remain under oath. You can continue with your testimony.
Thank you, Your Honor.
Go.
Now I just want to make sure we're on the right track. Now we're talking about the plaintiff's motion sequence 6, which was filed by order show cause, document 168, along with the affidavit of Jacob Landau, document 150, where he claimed, where he stated, one second, Your Honor, in paragraph 8, that defendant identified himself as Charlie, as well in paragraph 9, where defendant called Landau again, this time he's telling that he's going to get FBI involved in this litigation. Now, in order of course, along with the affidavit of Emmy Marion, document 151, affirmation of Emmy Marion, where she mentioned 3 complaint numbers. Now, the first complaint number that was made by defendant to the Department of Buildings, 3823-147, document 154, and 158-76, 158-7766, document 165, with the Department of Buildings by calling 311. Now, I would like to oppose that, Your Honor. The plaintiff claiming that the complaints that were filed was insufficient. Now, we go to the complaint that was made, complaint number 3823-147, document 154. Let me open it. Where we see, Your Honor, the description of the complaint. My opinion, work without a permit, false statements are all certificate of correction. Request a full re-inspection of all these violations. Then there is a number of violations, 10 of them. Now, the last violation by number 37005378P as in Peter is issued for a violation for electrical wirings without a permit for apartment B5. Now, once again, that the plaintiff are trying to prove that the complaint was filed, the file was insufficient. No basis for it, as far as I understand, a sufficient word. Therefore, I'm trying to prove, to show to the judge, why I did this complaint, and what my motive and what my recollection, according to what I come up to this point to make this complaint. So therefore, to show you it's not insufficient. That's the point. Now.
Okay, so it's not insufficient, it's substantiated.
I just cannot unsubstantiate. Not true, in other words. Now, I would like to show to the court the first complaint 3823147. Document 154, in motion 6, plaintiff claims the defendant violated the mandate of this court when he filed allegedly insufficient complaint number 3823147, where complaint states the violation 370053788P is the last violation of that complaint, which mentioned on that complaint. No application on file for breach circuit wiring throughout apartment 5B, fixtures, switches, and outlets. Document 164, that's that complaint, 78P. Honorable Court should understand once again, it's a complaint for a B5. That's why I am fully aware what's going on in B5 electrical wise. In 2017, numerous complaints were filed by the defendant, as well as the violation was issued. One second, I lost my thoughts. Okay. The violation was issued because the plaintiff, because of the defendant, Itam Chaimov, filed the complaint with the DOB prior in 2017. The complaint number 3610474. Document number 170. Overview for the complaint, July 17, 2017. Now, this violation was issued, and till 2022, the landlord couldn't clear this violation. But then all of a sudden, the violation is gone on the record. But I would like to show to the court how they misleading the information to the DOB, and I have the proof for it, how they said they saved the lie in the affidavit. Mr. Landau's affidavit, as well Mr. Joseph Banura, who is the electrician who allegedly did a job in apartment B5. Now, history of correction of violation 370053788P, which was issued for 5B. Permits to correct violation B00231373P as in Peter 1 expires November 11th.
Now, what is that you want me to see? Those numbers.
This is what's his name? A permit that was obtained by Jacob Landau. First, he obtained one permit, which is the number B00231373P1. I'll tell you the exhibit.
Okay. Say it one more time.
Sure. B as in boy 00231373-P as in Peter 1, which expires, Your Honor, that permit expires in November 5.
Now, where is this? Where can I find this in the record?
I'll show you. I'll tell you on the way of my. I have this down further. Everything documented, already been filed. I'm not filing anything new. Everything being filed before. as a proof.
Show me where the permit is in the record, sir. That's all I'm asking.
Okay, 1 second. Okay, 177, Your Honor. Now I'm opening 177. You shall see a permit.
Okay, now what do you want me to see in this permit? This is a letter.
This is a letter. No, it's not a permit. 1 second. I'm sorry, Your Honor. I'm just little.
177?
One second. Permit. 175. I'm sorry. Joe B. permit. 175. I'm opening it now. Here you go. You see this, Your Honor?
Okay, so this is a permit. Go ahead.
175. You see on the bottom it says to correct 37005375P. That's the last. That's the violation for apartment B5.
Where do you want me to look? No. This just came off. Where do you want me to look? To correct where? Where do you want me to see
You
that?
see this on the bottom, license number, then underneath license number, you see general wiring, correction, violation 37005378.
I don't see it, Judge.
It says general wire in the body of it. Violation.
Yes. You see this 37000578? That's for apartment B5.
It's 8T
Right.
for apartment 5B.
Right.
And 3535944 for loose wiring in lobby.
Right. As well for a lobby. Now, the main point I want the court underline apartment B5 to correct B5. Expires this violation. The permit expires on November 5th, 2019. You see it?
Yes.
Okay. Good.
I don't see that where it says expired. I'm trying to see.
On the top it says issued, and then it says
Oh, I see. Expired.
Expires. Good. Now, then second permit was issued. Then, and also, Mr. Landa, after that one, it was disapproved. He submitted to the DOB. The job was disapproved back in. Hold on, I'll tell you. 1 second. One second. I'm just confused myself. Okay. Okay. If you open, Your Honor, document 173. You see it, Your Honor?
Yes.
Okay. You see, certificate disapproved date on the first page, on the second page of document 173, we see that certificate disapproved date 8/23/2017. So that means, Your Honor, they already tried to submit the certificate of correction in 2017, but they have never pulled up the permit for that. To correct it. So they tried, so it was disapproved. So first attempt was tried. Now, as well, now I want to show the history of Jacob Landau correcting that violation. That as we spoke, as I already showed to the judge, for apartment B5. That's all. That's not. That's the. That's 10th one out of the 10 violations that I include in complaint that the plaintiffs are trying to prove that it was insufficient. Now,
unsubstantiated.
I cannot pronounce. Now, permit was issued by Joseph Banura, application number A010515, who has disciplinary.
Objection. Could the witness say? Could he say what he's reading from? He's just spewing out these numbers. He's got to go slowly, and he's got to direct it so I can follow. Not okay.
No, that's not okay for you. In counsel, you don't have to scream. You're talking very loud.
I'm sorry, Your Honor.
Mr. Kymar.
Yes.
Before we broke, I said to you, I want you to come back. I want you to say, this is what I did. This is what the building department found. And this is why it was substantiated. What I did was substantiated. It wasn't false, what I did. That's all I want you to do. Don't tell me what Mr. Jacob did. Tell me what you did. That's all I want you to do.
What I did is, Your Honor,
Stop. Listen. So this is the violation that you asked, you called the Department of Buildings to check on. Yes or no?
Yes.
Okay.
That's it.
Now,
Respect. Sorry.
Mr. Kymar, I can't keep letting you go around and around in circles. You have to listen and you have to follow my directions. What you're doing is not fair to me. It's not fair to Mr. Jacob, Mr. Israel, to Ms. Marion, and it's certainly not fair to the court reporter. You are going around and around in circles because you are not following my directions. And I'm not going to allow you to continue to do that. If you do not follow my directions, your case is going to be over. I'm going to listen to Ms. Marion, and I'm going to move on and make my decision. Now, you got to tell me, if you're going to follow my directions, you're going to do what I tell you to do, or you're going to continue to do what you want to do. You tell me how this is going to work.
It's your courtroom, Your Honor. Your rules.
Okay. So now, I'm going to ask you these questions. Now, this is how I need you to follow my lead. This is a violation. You've been telling me this all day, right?
Yes.
Document number 164. That's the violation that you called in, yes or no?
Yes.
Okay. That was done in 2017, correct?
Yes.
I'm not interested in that, okay? I'm interested in anything that you called in after 2020, 2021, and thereafter.
Exactly.
That's what you have to show me. The judge didn't say anything to you in 2017. The judge didn't say anything to you in 2018. The judge didn't say anything to you in 2019. It wasn't until 2020 that the judge directed you to not do something. Therefore, anything before that is of no consequence. Okay? So now, show me, based on what Ms. Marion has already put on the record, these are the claims that I'm saying that you, Mr. Kymar, you failed to follow the court's direction. That's all you have to do. You don't have to make up anything. She already said, this is it, 1, 2, 3, 4, 5, 6, 7, 8. These are the things. All you had to do is go, and I gave you that opportunity from 12 noon today to go back. Now you're back at what we talked about before, and I told you don't do it.
Okay, now I understand that the court understands of the B5.
No. I asked you, did you understand before, and you said yes. But you continue to do what you want, and that's why we are here, because you're not following the court's direction. Now I'm going to tell you, 2020, go back to what she said, some of the things that she already showed you, and say, I called this in. It was substantiated by the Department of Building. They found a violation. So I wasn't in violation of the court's order.
Okay.
Right? You could start from 2020 or you could start from 2022 from my order and work your way back. I don't care which way you do it, but you can't go back to 2017 because that's not in front of me. That's not before me.
Yeah, but Your Honor,
But Your Honor, nothing. But Your Honor, nothing. Either you're going to do that or I'm going to stop you. I'm telling you now. Either you're going to follow my direction or you're going to be finished and I'm going to let her close out and I'm going to move on. Okay? So you tell me how you want to do this. You're going to start at 2020 or you're going to go back to 2017?
2020, Your Honor.
Okay, let's do it.
Now, in November 27th, 2021, the violation was, the complaint was made by me.
Where? Tell me what document number you want me to look at.
Document, 1 second. Document. Uh,
154.
154? 47. 1 second. It's too much open here. 1 second. Yes. 154. Okay? Now, I filed this complaint. On the bottom, the 10th one of this complaint is my apartment. So now I'm trying to show to the court that it's not unsubstantiated. Okay, Your Honor? Now we move on.
Okay, now show me why you say it's not.
It's not substantiated. Why? Because, Your Honor, the landlord, when pull up the permit from the DOB to correct it, why it's not? Because the violation in this apartment are still occurring time. And I did send you a letter, Your Honor, asking for a writ. I filed a written permission for this court, asking for the permission to file a summons, subpoena of the licensed electrician who did inspect this apartment in 1 second. 1 second, Your Honor.
Okay, listen to me, Mr. Kymore. Listen to me. Look on this document. Can you see the document?
On what document?
The document that you asked me, number 154.
154, 1 second.
Now, you see that document?
154, 1 second.
Right, that's the same document where your number 10-3700-537-18. That's that document. Okay? That's the document you asked us to look at.
Yeah, 154.
Right? That's the document with your claim, apartment 5B is number 10.
Yes.
So you say. That is go.
Yes.
Now, listen to me. Why do you need to subpoena an electrician? The person that, listen to me, this report is filed by badge number 1761. That is the only person who could tell me what this document reads.
No, I'm not. No. This document to show you that this last one is my apartment. P is for my apartment.
It's the time off. Listen to me carefully. Okay? The place was inspected. You made a complaint on November 27th. This is what this document reads. Listen to me. They received the document on November 27th of 2021. Badge number 1751 went out on November 30th. On December 1st of 2021, that person, badge number 751, found no violation warranted or complaint at time of inspection. Okay? That's what this person found. Okay? That's what this reads.
As well
So
as...
the person, if you wanted to have somebody come in to explain this, would be badge number 1751. Not an electrician, but badge number 1751. That's the only person who could explain this document.
But I'm not trying to prove this document, Your Honor. I'm trying to show to the court that I called for an electrician to check.
It doesn't matter what you call for, sir. You gotta understand that's not this case. That's not this case. So now move on to another complaint that you made.
Also,
that I have to determine whether it was substantiated from the Department of Building, not document number 154. We have done document number 154 ad nauseum.
Okay.
Move on.
Now, as well, Your Honor, you are aware that I couldn't. The reason why I mistake that because I didn't know the word of the Staffel.
No. Move on. I'm making my determination.
No.
What I know. What is another one that Miss Marion?
As well, Miss Marion in her affirmation and Jacob Landau in his affidavit mentioned the complaint number, the document 165, Your Honor. Complaint to the Department of Building 1587766. One second.
Okay, and that would be complaint number 1587766. Correct?
Yes. Document 165.
Again, you made that complaint on November 27th. Is that correct?
Yes.
Okay.
That's
and on November 28th, badge number
unable to gain access.
25. And what does that say? That one says what? That one says that access was unable to gain access.
Access, right. Now, I would like to explain to the court, I would like to give the history to the Honorable Court about this violation.
I'm not interested in the violation.
But there was violation issued.
This is about. Move on. What's the next one that you made a complaint?
That's it. The complaint, the plaintiff attorney claims that I made. 1 second. 1 second. I cannot find. Oh, there you go. 1 second, I'm opening up. Document 329. That's a notice of rejection. That's when the attorney sends the letter saying, talking about the complaint. Document 329. Rejection. Notice of rejection. An objection to the letter of to the judge. Which the plaintiff attorney just mentioned that about this complaint 3860405 and 3860573.
I'm lost now. Wait. So I have document number 329. I'm just not understanding what he's saying. I didn't follow that. I have 329 up. I see that.
Go ahead, Mr. Kaimar. Now we are at 329. What do you want me to know?
Now, the complaint, the what's 329 on a page 2.
Okay, what do you want me to know?
The plaintiffs are claiming that I filed this complaint. I never filed this complaint. I never did, and besides that, before I never reject to the complaints that I filed. If I filed, I always says yes, I filed. Besides that, what's his name? I'm fully aware that I theoretically promised you not to file the complaint. So therefore, this complaint is not mine. Even though I sent on this letter, on this rejection, I asked the court if the court would allow, I will subpoena the record for my cell phone to show that for this time that no calls to 311 was ever made. Besides that, I provide a picture of this CT view of current time, which has no scaffold. So I would not file the scaffold, the complaint. Besides that, I'm aware that the word of the scaffolder has another word, and I would not risk, because the complaint that I made before within 6801 21st Avenue, I missed only this scaffold, different word for the scaffold, more professional word. I didn't know that professional word, scaffold. S something.
Go ahead, next.
So I did not file those complaints, and the plaintiff very well aware of that. And if Your Honor wish, I will sign a subpoena. I have 311 records for it. It was made at 6/23/2022 at 8:07 a.m.
Okay, what about the second complaint on this number? You have another one, 386-0573.
Yes, also I have not, there's the same building at same time. I have not filed those two complaints, Your Honor. Before, I never said, if it's my complaint, I never said no. Because I strongly believed, and I had some knowledge or understanding, this one is not mine. 1,000,000%, and I could assure, once again, check the video. It will show you that I was home. So that means only from home I could make this complaint. Now it would lead us to the phone. If it's 311 close, then we could order 311. We could order telephone record.
Okay. The next complaint. What's next?
Oh, the next one. On a page 5. They didn't even include that in the motion.
What is the next document you want me to look at, Mr. Kaimar?
On the next document.
Could I just put an objection on the record? Those aren't the complaints that he just said. Both those complaints are not complaints that plaintiff moved forward on, or even where we even mentioned those. So I don't know where you got
asked
those complaints
when you ask the witness.
So that's not the subject.
Okay, Mr. Kaimar, continue. Thank you, Mr. Marion.
Now, once again, one second. Now, I would like to say the legal argument.
The what?
A legal argument? How do you say this?
What other complaint is it that you, based on listen to me, Ms. Marion has set out certain behavior, given a list of exhibits that she believes that you violated the court order. What you should have done during the break is to go through that 1, 2, 3, 4, and say, this is it, this is what I did, this was substantiated if I didn't to do.
Which I'm trying to say, Your Honor, I have to prove to the court why I did make this complaint. And I'm trying to show to the court that they actually tried to correct it and they've allegedly corrected it this. But at the same time, they have this affidavit, send it to the DOB.
Mr. Kaiser, what you cannot do is go and get documents that you think are in your favor. This is their case. These are the specific ones that they're talking about. You could talk about other ones, but that's not helping your case as to what they are saying. And that's what you're doing. You're trying to go around or show me something that's not part of this case. She showed you exhibit 1, 2, 3, 4, 5, all of the things that she is asking the court to say that you disobeyed the court order. Those are the documents that you should be looking at and saying, no, I did this because when I made the complaint, the Department of Buildings substantiated, said, yes, you were right, there were violations. That's all you have to do.
But
you can't pick out what you want if that's not what they're arguing. They're not asking you for this. You're going to documents that they're not even asking the court to look at. That's their case. This is their case. You have to rebut everything that they said.
I filed the complaint that they're saying with the 10th violation on it to re-inspect, and that was my opinion for them to re-inspect. Why? Because they supposedly corrected a violation.
Right, and that's the point, I'm making. That you filed after the judge told you not to, and now you have to show, yeah, but when I did it, the Department of Buildings found in my favor. That's all I'm asking you to do. That's all I'm asking you to do.
But what I'm saying is...
So the first thing you have to do, listen to me, the first thing you have to do is go to what they say. Okay? They said Exhibit 1. This is the Exhibit 1, and this is what we said that you did. You have to go against that. You have to prove against that. Right? That's what you have to do. You have to say, this is, when I made this call, the Department of Buildings agreed with me that there was a violation.
Okay. Okay.
Oh, okay. You keep saying okay.
No,
okay. You go back to doing what you want to do. I've explained this over 5 times, I'm sure.
Okay. Now, with the violation, 1 second. I'm gonna go.
Let's do it this way. I'm gonna go back to just this morning. I'm not even going back to the other days. We're gonna just start with this morning. Okay. Let's go to.
The plaintiff filed Exhibit 165, document 165, violation.
Okay, we already did 165. So
now, Your Honor, I
165. We already did 165. Move forward.
I state everything in document 364, Your Honor. It's all I have to say on both motions. I combine them this way, both affidavits. So this way, the judge will know my position on motion sequence 6 and the motion sequence 11, which both of them for a contempt against the defendant. If I'm losing the thoughts just because of my medicine that I take, Your Honor, just because makes me
no,
like...
that's not it. That's not it. Don't do that.
Or I just did not...
Time off. Don't do that. Don't do that.
Don't do what?
That is not why. That is not why. Don't do that. Okay? It's not about the medication. It's
No, I'm not saying that, Your Honor. No, I'm not saying. I'm saying maybe I cannot say that because I took my medicine today and I feel like lightheaded today. That's why. I did not show you the proper way. That's why. It's not. Besides that, Your Honor, 364 should explain my position, Your Honor. Document 364. It includes...
Mr. Kymar.
Yes.
Let me just tell you about 364. Okay, if you don't want me to look at 364 because 364 will put you in stark violation of what this court told you not to do.
Why would that?
Anything more you want to say, Mr. Carmel?
No, Your Honor. I'd like to say to the court, when I filed that complaint that includes 10 violations, and I asked for the court for the DOB to reinspect, I strongly believed, and I did review the certificate of correction of Jacob Landau and certificate and as well licensee Joseph Banura, which is mentioned on the violation, who's correcting the violation on the permit that you saw. And as well, I provided that the records of that Joseph Banura has disciplinary violations, history of disciplinary. He was suspended for 2.5 years. So
Mr. that is not my case. That is not my case. Anything you want to talk about is contempt hearing.
Yes. The second allegation, they're saying that the plaintiff saying that I called and I harassed and did not call my name, which is untrue. I never called myself as a Charlie. That's number one. Number two, there's no reason. They have the caller ID. Besides, they have all the recordings are recorded in the office. Why they have not providing these records to show how did I threaten them? When she said call to my attorney, I said, listen, I'm not going to call to your attorney because of my leakage issues. And Super came down that day. Take a look, and I have the video that Super came in and he saw the leakage. So I have to call to the landlord's attorney. I said, I call to the landlord or I call to the HPD and what's his name, DOB. That's it. Now they're getting this as a harassment. But in a previous order, August 6, 2020, the Judge Barry Schiffman as well said that mentioning HPD or DOB is not considered as a threat. That's as an option. And that's the public permittee. I have the rights. If it's included public permittee, when the Jacob Landau's or his licensee files for the permit, I have the full rights to ask for inspections or anything else from the DOB. Now, I ask this court consider my financial situation. I'm disabled. I live out of the paycheck. It's $873, and that's it. So and besides that, harassing. It's not if I file the complaint, it's not harassing the way. Besides that, they came. They see there's no violation. How does it impact to the relationship of Jacob Landau? You know why? Because when they came in to check my electricity, they accidentally find out about the illegal wirings throughout the building for the central lights. Because the Dooley previous super, installed it. I had no clue, but when they came into my apartment, inspector as well saw that, even though I didn't complain about it.
Mr. Kaimov, you have to talk about things from 2020 going forward.
Once again, if I file the complaint to the DOB, it's not to harm Mr. Jacob Landau. God forbid, besides that, according to our...
You filed a complaint with the DOB after the judge told you not to, and the DOB says that he was in compliance. You are in contempt of this court. That's all we're looking at. That's all this case is about. Right? You can do what you want. You're absolutely right. But if you're in violation of a court order, that equals contempt. Right? Citizens are able to do whatever they like.
As well as...
when citizens come to court and a judge says to them do not do this, or do this, and you fail to not do that, or to do that, then that equals contempt of court. Now, Ms. Marion, what is it that you would like to say in a closing statement?
Your Honor, if I may just finish my statement.
You may. Go ahead.
As well, I'm trying to. I want the court to whenever consider to go over my affidavit of affirmation 169 document along with the exhibits 169 through to 183. That include the exhibits. That's where I state and explain how that I got all information afterwards. Whatever is public information, it's whatever is information on the DOB, and I include all the exhibits in there, Your Honor. I finish, Your Honor.
Ms. Marion.
Thank you, Your Honor. Your Honor, as this court is well aware, a court has the power to punish by fine and imprisonment for either a neglect or a violation of duty or other misconduct by which a right or a remedy of a party to a civil action or a special proceeding pending before the court may be defeated, impaired, impeded, and prejudiced. And looking to Judiciary Law 753, and also in the matter of McCormick, MCCORMICK versus Axelrod, AXELROD, 59 New York 2nd, 574, 1983. Court of Appeals set forth the necessary elements to support a finding of civil contempt. First, it must be determined that a lawful order of the court clearly expressing an unequivocal mandate was in effect. I direct the court's attention, and the court is already well aware and probably ad nauseum from this hearing, but I will say it again for the record that there was an order issued by the court on August 6, 2020, and that is NYSIF document number 51. There was an order issued on June 17, 2021, and that is NYSIF document number 108. And then there was again an order issued by this court, Your Honor, both on July 13, 2022, in the context of the hearing that was going on, and on July 16, 2022, in a written order, which is NYSIF document number 323. So there clearly were lawful orders, clearly expressing an unequivocal mandate that was in effect. And those unequivocal mandates were within the context of the first two orders, not to file any unsubstantiated complaints with the DOB. The third order, which emanated from the July 13th hearing before Your Honor, wherein Your Honor specifically mandated, as the court says, clear order or mandate, expressing an unequivocal mandate, and the July 13th transcript from 2022 has an unequivocal mandate from this court, where this court said to the defendant, do not do anything with regard to this case. And you said, I mean anything. That's Plaintiff's Exhibit 13 that we are prepared to offer as an exhibit for the court. And we'll provide that to the court with all the exhibits, actually, if the court wants. And I have an exhibit list that has the NYSIF links to it, as well as the ones that aren't connected to NYSIF that I will provide to the court and copy to the defendant, of course. In that transcript, like I said, Your Honor told the defendant not to do anything with regard to this case. Then there's the fourth mandate from the court that the court, Your Honor, issued a written order on July 16, 2022 that also had unequivocal mandates and orders telling the defendant not to do anything, not to contact anyone, including the court. The second element.
Objection, Your Honor.
Or civil.
Objection.
No, Mr. Kimoff. She did not interrupt you. You will not interrupt her. Go ahead, Ms. Marion.
The second element, it must appear with reasonable certainty that the orders have been disobeyed, And then the third element is that the party to be held in contempt must have knowledge of the court's order, although it is not necessary that the order actually have been served upon the party. In the context of this hearing, on the first date of the hearing, my colleague, Ms. Andrea Caruso, unequivocally got testimony, I shouldn't say unequivocally, but there was testimony from the defendant where he unequivocally stated that he was aware of both of the court orders, the first two that I stated, which were the two that were plaintiff's exhibit number 1 and 2, which is NYSIF document number 51 and NYSIF document number 108. The defendant acknowledged and admitted that he was clearly aware of those two orders. As to the third order issued in the context of the hearing on July 13, 2022, it's clear that the defendant was at the hearing and actually engaging in colloquy with Your Honor with regard to Your Honor's repeated mandates and Your Honor's not only repeated mandate, but Your Honor's explicit instructions and explanations and patience to have Q&A, question and answer about what Your Honor was saying, so that Your Honor made it excruciatingly clear that this defendant understood what Your Honor was saying on July 13, 2022. So it's clear that he knew about that mandate. And then on July 16, 2022, Your Honor filed the written order on NYSIF, and we know from the repeated filings on NYSIF after July 16, 2022, that this defendant is well aware of what gets filed on NYSIF. He is very, very sophisticated in terms of his use of NYSIF, even filing on NYSIF on October 31st, today's date at 10 a.m., what he now wishes the court to look at with regard to his conclusions and summations. I would ask the court leave for me to be able to review that, because I haven't had an opportunity to review that because the hearing started today. So I would ask for leave. If the court is so inclined, the court might not need it or might not deem it necessary, but I have not reviewed what he's filed on NYSIF, and insofar as the court is going to consider that, I obviously would like an opportunity to respond to that written submission if the court, as I said, deems it necessary. I'm going to come back to the second element, which is it must appear with reasonable certainty that the order has been disobeyed. And then the fourth element is prejudice to the rights of the party to the litigation must be demonstrated. And prejudice can be shown by a violation of the clear and unequivocal mandate of the court, and then that there was prejudice as a result of the violations. Mr. Landau testified today. The prejudice to his business relations with Department of Buildings, the constant disruption to his business of constantly having to stop to go and answer the calls, of the extortion that he testified to on the last court date. He testified to the fact that he has had to go down personally, that the defendant summoned him to his apartment, and when he summoned him to his apartment, he had an iPad, and this is in the record from the last hearing in August of this year, and he had that the defendant had on the iPad a home, and said, well, maybe you should buy me one of these homes, and then this will stop if you buy me a home.
Objection,
You're a
Your
smart man,
Honor.
Jacob. You're a man that is in business, and it would behoove you to actually buy me a home. And that the plaintiff, Mr. Jacob Landau, testified before he testified about being the defendant trying to extort him for a private home. He testified
Objection,
that
Your
before
Honor.
that he actually
Objection, Your Honor.
said to him, "Why don't you?"
Mr. Kimoff, I want you to stop interrupting.
Objection.
Not
This
interrupt.
motion.
Mr. Kimoff, I want you to put your computer on mute. Okay, that's what I want you to do.
Mr. Jacob Landau testified that prior to being extorted for a home, that there was extortion for a job, whereas the defendant said to him, well, give me a job. Employ me as a real estate broker. Let me work for you. and that Mr. Landau said, no, I'm not going to have you work for me, absolutely not. And that led to then the extortion of the home. And then that led to the filing of these DOB complaints because it just escalated. But I'm going to go back a little further to his testimony. I probably should have done it in chronological order and not reverse chronological order, and I apologize for that. But that what it started with is that this defendant moved into an apartment of Mr. Landau's with his girlfriend. The defendant denies it was his girlfriend. Whoever it was, it doesn't matter, girlfriend or not girlfriend. He was living in an apartment with somebody else whose name was on the lease and not the defendant's name on the lease. And that at some point he came to Mr. Landau, and Mr. Landau testified, and he said that he was living out on the street because he got kicked out of that apartment. And he begged Mr. Landau to give him a place to live. And Mr. Landau gave him an apartment. And he said, Mr. Landau gave him an apartment and put this defendant in an apartment and gave him an apartment, even though he got kicked out of his partner or whoever he was living with, his roommate's apartment. And then, after doing that, the defendant said, well, I want a different apartment. And he kept asking, and he kept calling, and he repeatedly nagged, even if you don't want it to rise to call it a harassment at that point, but wouldn't stop until Mr. Landau said, okay, I'll get you another apartment. And then Mr. Landau got him another apartment. And then the defendant said, but wait, I want it to be renovated a certain way. And so the defendant said, I'll renovate it myself. You just, give me time. And so what Mr. Landau did is he gave the defendant time, and at that time the defendant had two apartments. There is a housing court, Your Honor, and I would ask the court to take judicial notice that there is a housing court decision and a housing court petition that was filed by by the defendant, and in that housing court petition that was filed by the defendant, it shows that the defendant was actually subletting that apartment. That was actually, I showed that to the defendant when I was cross-examining him, and I don't believe that the court allowed that as an exhibit, but I would ask the court to take judicial notice of that housing court proceeding, and I believe I did ask the court to take judicial notice of that housing court proceeding at the time that showed, and the defendant actually acknowledged that he was an individual that was engaged in a housing court proceeding where he was the petitioner and he was actually suing the person that he subletted his other apartment to, even though he told Mr. Landau that he needed that apartment because his new apartment that he got wasn't yet renovated. And Mr. Landau explained. He kept telling me that he needed to complete the renovations. That's why he had both apartments. And then Mr. Landau testified and said, and then he told me that he was going to get me the keys back. He was going to get me the keys back, but yet he never got me the keys back. And all along, this defendant was making a lot of money. The housing court shows that it was $30,000 that he was actually getting from this individual who was who he was subletting to. And then after he finally, Mr. Landau says enough is enough, and finally he gives up that apartment, then he's in his own apartment, and that's when he starts continuing to still harass Mr. Landau and the plaintiffs. And it's the plaintiff's business. And the plaintiffs have multiple housing properties. And every time, every time that there is a call, a complaint, harassment, it stops business. Everybody has to stop. Everybody has to respond. And then he threatens to go not just to the DOB that he goes to constantly, but also he goes to the Attorney General's office he's filed complaints with. He's filed complaints with the FBI. He's filed complaints with the Internal Revenue Service. Anything he can do. And that's because he actually told Mr. Landau that after he was in his own apartment and Mr. Landau took away his fruitful subletting income that he had, he got mad when he lost that income from that sublet. And he got mad and he said, okay, you're a smart guy. You don't want me to file complaints against you. Give me a job. And he said, no, I'm not going to give you a job. Sorry, sir, I'm not giving you a job. You're not a real estate broker. And after that, he said, okay, you're a smart man. You don't want to give me a job? Then you're a smart man. You don't want this to continue. Give me a house. And then he said, I'm not buying you a house. I'm not doing that. And that's when this incessant filing of DOB complaints started and continued and continues to this day, even when the hearing is going on. I understand that this individual defendant said that he's not the one who filed the most recent complaint, even when this court was hearing, as to the sidewalk shed. But we have in evidence, Your Honor, a sidewalk shed violation, and in fact, not a sidewalk violation, a sidewalk complaint as to a sidewalk shed or scaffolding. There's testimony in the record here, and there's testimony in the record here that the defendant here admitted. He admitted that, in fact, that there was, and this was again when Andrea Caruso was examining the defendant. He admitted that there was, in fact, that there had been a prior complaint made for scaffolding, that had been resolved, and that was one of the numbers that is in plaintiff's number 3, which is the complaint filed on November 27, 2021, and that in fact, and I'll get those exact numbers.
What's the number?
Sorry, if you just give me 1 second, I have it right here. That plaintiff's exhibit number 18, which is NYSEF number 255, which is that was specifically related to the scaffolding complaint, and that 255 was a NYSEF document. 255 was filed by the defendant. He admitted to filing that and that the photo that's in Exhibit 255 of the front of the building, that the defendant, which is page number 7 of 10 of NYSEF document 255, that the defendant admitted that the front of the building appeared as it appeared in that photograph, which is page number 7 of 10 of NYSEF document 255, and he admitted that the front of the building appeared as it did in that photograph when he filed his complaint on November of 2021, November 27, 2021. And in fact, there is absolutely no scaffolding and there is absolutely no sidewalk shed. So at the time that he filed the complaint, it wasn't there. Now, we know from his testimony, him being the defendant, that the testimony of the defendant, what he is claiming and what his defense is and what he said to this court in this hearing is that he said, well, he has a gripe with what DOB did. In other words, he said that DOB should not have issued certificates of corrections. And that's what he keeps trying to show to this court. He complains that the DOB should not have issued certificates of corrections. It is not for this defendant to say what the regulatory agency DOB should do, should accept, or should not accept. And when this defendant filed a complaint on November 27, 2021, it's not his opinion, as he said. The exhibit is very clear. And the exhibit specifically says in very, very clear language of what he said. And he said that there were false statements in all certificates of complaints filed. That's what he said. That wasn't his opinion. He made an absolute statement that there were false complaints, there were false statements in all certificates of complaints filed. That, Your Honor, is an unsubstantiated complaint to the DOB in violation of Judge Bailey Schiffman's both her orders. Because that is unsubstantiated complaint, because there were, one, not false statements made in those certificates of corrections. And we know that because the DOB dismissed the complaints, the DOB accepted the certificates of corrections, and the DOB then also found in many of the complaints filed no violation warranted. And that was brought out through the testimony of the defendant and also in exhibits numbers 4
What's the nice?
through 15, plaintiff's exhibits number 4 through 15 at this hearing.
You're on.
What this defendant is trying to say here is that he has a right as a citizen to file complaints. And there are whistleblower statutes. And we understand that there are whistleblower statutes, and we also understand that there is a constitution here. But what happens here, Your Honor, is this isn't just filing complaints, and this isn't just an individual doing a public good. What this defendant has done is this defendant smackly finds himself exactly what the law prohibits. And that is that he cannot violate a court order or a court mandate. And that's what he has done here. This isn't a whistleblower doing well. This isn't somebody doing for public good. What the record shows here, and also I would submit to the court, the testimony that we have heard from the defendant. I don't know, I've never seen the medical documentation, but I know that the defendant came on here several times and said he wasn't ready for the hearing, and he did that after he first asked the court to delay the hearing. He's constantly interrupted. He's constantly asked for repetitive instructions. He's constantly delayed and been very taxing during this hearing. And I raise that because sometimes the record doesn't actually reflect that clearly. I do think the record here does reflect it pretty clearly. But I raise that because during the course of this hearing, not only has that gone on, but it has caused like a great delay. A great delay has occurred. And even at the time where, he said that, he needed to go, he needed to stop the hearing and there was an ambulance. He was at home that night. I mean, he was treated and released. And I'm not taking umbrage, with an individual's medical condition. But what we have here is we have an individual that will not cease. His harassment, his extortion, his degradation, his impairing the business relationships, that is prejudice to the plaintiffs here. And it is incessant, and it has not ceased at any time. And this is not an individual who is doing some public good as a whistleblower, but we know that in fact, because we know that one of the main violations that he said was an electrical problem in his own apartment, 5B, where in fact there was inspections done at 5B, and they issued, and the DOB said, inspection done, no violation. So that has to be the last word, that the complaint is not a substantiated complaint. And after we have unsubstantiated complaints in clear violation of Judge Bailey Schiffman's order, then we have, Your Honor, on July 13th, telling the defendant, do not do anything with regard to this case. And I understand that this defendant is denying that the complaint with regard to the scaffolding, the sidewalk shed, is not him, with the latest one. But if Mr. Landau said, and these are the words he used this morning, he said his fingerprints are all over it. Mr. Landau is the management of plaintiffs. And there are numerous plaintiffs in this case. And he is the manager for all of these plaintiffs. And he has been in this business for decades. And he has been dealing with this defendant for a significant amount of time. And when Mr. Landau said the defendant's fingerprints is all over this, he was saying the defendant's fingerprint is all over this because he is the only one that makes complaints like this.
Objection.
Mr. Landau has never gotten complaint from anybody with regard to a sidewalk shed or scaffolding. He gets complaints for individuals for the individual apartment. So when he's saying this is what this defendant does, because it's only this defendant who makes complaints about a sidewalk shed, and we have that in the record from the prior complaint that he did, and lo and behold, when this hearing is happening, he does it again. But even if the court finds and believes the defendant, or finds that there's not enough to show with regard to the burden, and the burden here is clear and convincing, but even if the court finds that that's not clear and convincing, we nevertheless have the defendant filing numerous additional discovery demands. The court said, do not do anything with regard to this case. And then the court's written order says, do not contact the court. And what does he do? He files NYSIF number 331, NYSIF number 332, NYSIF number 333, and NYSIF number, I think this number is wrong, 340. I think I put 240, but I think it should be 340. And what those are that's a second demand for documents and information, NYSIF number 331, a notice to admit,
Your Honor, now we want, Your Honor.
Interrogatories, NYSIF number 331, 333, and then he does a follow-up demand for discovery, NYSIF number 340. Plaintiffs cannot ignore and are not permitted to ignore discovery demands. Judge Nipel is the judge who looks over the discovery in this case, and we have to respond to discovery demands. So not only did that cause the plaintiffs to have to then pay my law firm to actually look at these numerous additional demands, which are many, 40 and 50 and 60 pages long, and then we had to respond and do a good faith response before we could file a motion, because we're required by the rules of the court to do a good faith letter. So then we had to do a good faith letter and respond to his 72 demands and show him where we have previously provided the documents in his 72 requests that were repeats of prior 72 requests. And then after doing that, then we were permitted to file a motion, but then in fact had to file a motion. And in addition to doing that, what he did was, even after the court said, don't do another thing with regard to this case, not a thing, what he did was, he then files a letter to the court, which is NYSIF number 360, and he asked the court to sign a subpoena for the electrician Joseph Bonura, Bonura. And the court, on April 11th of 2022, NYSIF document number 273 had refused to sign a subpoena for the electrician Joseph Bonura. And what that is an example of is the repetitive, the incessant, and the behavior of this defendant, his failure to actually listen to what anybody says, but most importantly and significantly, a justice of the Supreme Court of the state of New York. So if he's unwilling to listen to a justice of the state court of Supreme Court, Your Honor understands what the prejudice and the impact and what the effect of his behavior has had on the plaintiffs. And that's the prejudice component. And I submit to the court that with regard to the second element, it must appear with reasonable certainty that the order has been disobeyed. I submit to the court that the record from this hearing absolutely shows with a reasonable degree of certainty that the order has been disobeyed. And to just put one sample from the hearing to just that really cements this home is that during the hearing, and the transcript shows this, and I have the exact page number of the transcript, I'm just getting to the exact page number, but it was in at page 104 of the transcript from March 23rd, 2022, the defendant admitted that when he filed the complaint from November 21st, 2021, that he did not have a certificate of correction, that he didn't view a certificate of correction. And yet, nevertheless, he made the complaint that there were false statements in all certificates of corrections for all the violations that he listed. And yet, the testimony is clear from that March date, March 23rd of 2021 at page 104, that he acknowledged that he didn't ever see a certificate of a certificate of correction for the violation that was being discussed at page 105.
What page 105 we're talking
104,
about?
which was NYSIF 255. And so it's clear that at the time when he made his complaint that all statements in the false in the certificates of correction, I'm sorry, I'm going to repeat that. It's clear when he made his statement on November 21st, 2022 to the DOB that when he made his complaints and his statements that there were false statements in all the certificates of corrections, it's clear and unequivocal that that was not only an unsubstantiated statement or complaint to DOB in violation of Judge Bailey Schiffman's order, it was absolutely false, and he had no basis to ever make that complaint because he admitted that for some of these violations or violation numbers, he never even saw a certificate of correction. So he could never, ever have ever said with any degree of certainty, let alone with enough to show that it's substantiated, that in fact the complaint wasn't false. Closing up, Your Honor, one last point that I just would like to make is that I understand that the burden here is clear and convincing, but I submit to the court based upon what I just said that it's beyond clear and convincing. I mean, that the plaintiffs definitely meet their burden with regard to that complaint. Willfulness, Your Honor, is not a required element of civil contempt. However, when the court is considering whether or not the level of egregiousness in a civil contempt and whether or not to impose jail in addition to a fine, the court can consider willfulness. And I submit to the court that that's something that this court should consider, and we're asking the court to consider that. And the meaning to be attached to the court's level of willfulness language is that the contemnors, CONTEMNOR, S action, must connote an intentionality not otherwise indicative of wrongfulness. And I submit to the court that the case law establishes willfulness, although it's not an element of civil contempt, it can be considered to go to the motive when disobeying a court's order. And when disobeying a court's order defeats, impairs, impedes, or prejudices the rights or remedies of a party. And that's Eldedan, that's EL-DEHDAN versus same name, Eldedan, 26 New York 3rd, 19, and that's the year is 2015. And that's the Court of Appeals. And the Court of Appeals looking at willfulness in the context of civil contempt and in saying that although it's not necessarily an element, but it clearly, the statute and both the case law shows that it's absolutely to be considered in looking to see what the level of impeding or defeating a court's mandate. And specifically, I bring that up with regard to Your Honor's mandates, because moving on from Judge Bailey Schiffman's orders and the unsubstantiated complaints filed, Your Honor issued a mandate on July 13th, unequivocally clear, and then again on July 16th issued another order. And the violation of both the mandate and the order, and the orders, there were several orders in that July 16, 2022 order issued by the court, but the violations of those orders clearly impaired, impeded, and prejudiced the plaintiffs in this case and their rights and remedies. This case has been going on for quite some time. My clients have been paying attorney's fees for quite some time. My clients have not been able to even get to depositions, let alone get past document disclosure. This hearing has been pending for quite some time. We filed our order to show cause last year. The order to show cause was signed in January of 2022 is when it was signed. That's how long. We're rounding the next year right now. That's how long my clients have had to deal with this. I submit to the court that that is res ipsa, defeating, impairing, impeding, prejudicing the rights and remedies of a party. And I submit to the court that I understand what the defendant is saying, that he has a right. His contention is, and it's true, citizens of this great nation of ours, at least as long as it's still a democratic republic, and God hope it remains that way, we can all only hope and pray and vote, but that we have a right to be whistleblowers. This is not a whistleblower. This is an individual who has it in his head and has had it in his head from day one that he is going to extort and take advantage of this man who is the manager of plaintiffs, and that he will stop at nothing. At nothing. The testimony showed that he would try to drive by apartments. He would make allegations of apartments in neighborhoods he didn't live at. He doesn't even have a car, but yet he would pay for a taxi to drive by. So when he says to the court,
Objection, Your Honor. Objection, Your Honor.
He made a lot of money subletting his apartment, and he obviously has an iPad because he showed Mr. Landau an iPad. He obviously has a computer, so he's got sufficient enough funds that he can afford all of this electronic material.
Objection, Your Honor.
But yet he says to the court that he does not, and he files for disability, and he gets disability, and that's fine, and that's his right, and that's another regulatory agency to oversee. That's not for me to comment on, but I just want that to be a consideration. And that as compared to prejudicing the rights of plaintiffs who have a right, they have a Second Amendment right to actually bring their causes to court and to try and get to address their grievances. And those rights have significantly been impaired to be allowed to address their grievances in a court of law just when this hearing is going on. But prior to that, to be allowed to conduct their business with DOB, and their right to conduct that business has been significantly impaired. Thank you, Your Honor.
Okay, Counsel, you said all of that. You didn't tell me what you wanted.
We're asking that this individual be fined, and I ask that he be fined in an amount. I ask him to be fined as to each and every violation that he filed with the court after the date when the court order said, after the date of Judge Bailey Schiffman's order, the November 21st, 2022. And also we're asking for a period of jail time based upon his willfulness.
Objection, Your Honor.
Okay, briefly, Mr. Kimoff, I'm going to give you an opportunity to say something. What else would you like to say? Briefly.
In regards to motion sequence 11, it's very clear from the Judge Nipel order. Defendant motion to strike, extend time to file, note of issue, motion sequence 8. plaintiff's cross motion 9 are decided as follows. Defendant motion is denied as entirely, and plaintiff cross motion is granted to the extent quashing defendant discovery demands set forth in the motion. Now,
Okay, hold on 1 second, Mr. Kaimoff. That's not my case. Okay, I know she alluded to it, but
that's a
not what
motion
she
sequence
did.
11, Your Honor.
I'm sorry?
That's a motion sequence 11.
Okay, sir, we're talking about the contempt hearing, okay?
Contempt hearing, exactly. Motion sequence 11, because they said that I was in contempt of court order of Judge Neipel, which plaintiff attorney just mentioned it. I have not made a statement on that.
I didn't say anything about violation of Judge Neipel's order.
She said you said Judge Neipel's name, but you didn't.
And you also as well,
I'm trying to get him to understand that just because you said his name, you were not talking about the order.
When you were talking about discovery.
Right, but that's not the contempt hearing. That's two separate and apart things.
Correct. But the plaintiff attorney include that in here. Should I comment on that, or should I wait till?
She wasn't talking about the motion itself. She was just talking about.
When you judge first,
not talking about this.
And I was gonna object.
Talking about discovery prior to Judge Bailey Schiffman, not this one. That was prior to. She just mentioned the name. She wasn't talking about the case itself.
Okay, in reference to a motion sequence 11, should I?
No, she was not talking about motion sequence 11.
So we're dealing with motion sequence 6, right, Your Honor?
Mr. Kaimoff, do you have anything more you want to say?
In reference to the motion sequence 6, I would like to court to consider my affidavit, which was filed. 1 second.
If I consider your, which one is that?
336, Your Honor. Affidavit affirmation of motion number 11. 336. I have nothing to add more than that, Your Honor.
Okay, I'm not doing motion sequence 11, sir.
But the plaintiff just mentioned it for the last 5 minutes.
She mentioned Judge Neipel's name. She did not mention motion sequence 11.
She mentioned it. She mentioned it. The discovery.
That was prior to. That was the discovery that happened prior to. You was before Judge Neipel. Prior to.
Your Honor.
Bailey Schiffman. You can't talk while I'm talking. You can't possibly understand what I'm saying if you're talking while I'm talking. I'm trying to explain to you. When she said Judge Neipel's name, it wasn't in relationship to motion sequence 11. It was reference to something that happened prior to Bailey Schiffman. Way back. Okay? Which I won't even deal with that, okay? So we're up to this, okay? Now let me just say this to you, to both of you. I'm not dealing with what came in this morning. Okay, I'm telling you, if I deal with what happened this morning, Mr. Kaimoff, you would definitely be in contempt of court. Okay, because I told you don't do it. That I know I told you.
I understood. I did not understand.
So, don't tell me what you understood. I don't want to hear it. Okay, I believe you understood everything I said. You know how I'm going to tell you this. I'm going to say this for the record, and then I'm going to be finished. You know how I know that you understood everything I said? Because one thing about me, and the record will reflect, I say to you what I said. Then I say to you, do you understand? And then you say to me, yes. And then I say to you, tell me in your own words what it is that you understand or understood me to say. And then you tell me what you understood me to say. And then you go and do what you want to do anyway, which is your right. Okay? And that's how I know you understood everything I said. So here's my decision.
Your Honor, may I?
Okay? No, you may not. You have spoken, Ms. Marion has spoken, and I am speaking the last words on this motion for contempt of court. Okay? We started this case on a very bad note. Okay? Which I'm forgetting about. Because I said I was going to forget about it. And I'm forgetting about it. Right? Revamp. We came back. This is when Ms. Caruso was still in the case. And you said to me, Mr. Kaimon, that you didn't understand the sequence of the certificate of correction in relationship to you filing these numerous violations. And at one point, I believed you. At one point, I believed you, and I wanted to believe you with all my heart and soul. But then, as this case kept going on and on and on and on and on, you have shown yourself to be very shrewd.
What is that, shrewd?
A lack of a better word. Very shrewd.
What is that?
You probably know how to move this court better than Miss Marion and me. Put together, and I'm going to add Miss Caruso in there too. Okay? And I'm saying to you,
I don't understand.
that I have bent over backwards to the point where I even had to admonish Miss Marion because I believe that she thought that I was not paying close attention, or she might have thought that I was, not that she thought I was ever advocating, but I was giving you so much leeway that she was on fire, that one day she was beat red, and we had to stop the case so that we could all gather ourselves. And I gave everybody that opportunity, just like I gave you opportunities when you were ill, when you said that you couldn't come to court. Opportunity be after opportunity. And every time when you said you was ill, what would you do? You would you would file pages and pages and pages of information to this court, asking the court. You even came to the court building. If you're sick, and I granted you that you were ill, I gave you all the deference that I could possibly give to you, and you showed me otherwise. So when you just kept making a fool out of me as far as I'm concerned. But that's fine, because that's what you have to do. We have to sit, we have to be objective, and we have to move forward. So based on a contempt hearing and all of the elements that I have to check off, 1, 2, 3, 4, and then make my ruling, you have not complied with anything that the Bailey Schiffman told you to do, what I told you to do, and even now, today, as late as 10 o'clock this morning, you're filing papers that I told you do not do.
When did you tell me?
If you don't listen to me and you know you're going to see me, I know that you did these things in the Department of Building. Now, did you do everything? Maybe, maybe not. But you did enough that this court could find you in contempt. Will I jail you? No, I won't. Why? Because jailing you is not going to solve this problem. Will I fine you? Yes. Will Mr. Landau?
Your Honor, I have $12 on my account. $12 till tomorrow.
Okay, Mr.
Tomorrow.
Kymar, stop it, Mr. Kymar. The reporter cannot listen, cannot record if you're talking over top of me. And that behavior is part of why I find you in contempt, because over and over, every time I ask you not to, and sometimes not only have I asked you, I have begged you, I have pleaded with you to, as we use the word ad nauseum, where I make myself sick. I'm sure I made Mr. Landau, both Mr. Jacob and Mr. Israel, Miss Marion, and now the court reporter are probably sick of me begging you over and over to stop talking over me, to listen to the direction of the court. And for whatever reason, you don't want to do it. Okay? And that's what brings you to contempt of court. If the court says don't do it, don't do it. If the court says do it, do it. For whatever reason, you have a problem with following direction. But I know that you know the outcome because you said it. I don't have the money to pay. So you know what this outcome could have been. That at the end, the court can say you owe some monies. You owe. And I can't put a value on it except that I'm going to ask Ms. Marion to send me the attorney fees that Mr. Jacob has to pay. I need that. I need you to send it to me. I need you to send it to Mr. Kaimoff. I'm going to look at it. You're going to look at it. You can say what you think is objectionable or not, but I've been here, so I know the work. I know the work, and I'm telling you, whatever it is, I'm going to fine you that amount because it's unfair.
I don't have this money.
I told you, quiet. Here you go again. It's unfair for you.
I $12 in my account.
It's not even unfair. At this point, it's contemptuous of you to continue to go to the Department of Buildings and file on these buildings that managed by Mr. Jacob Landau and cause him this kind of fees that he has to at least pay his attorneys. I don't have any documentation, and I don't want it because this is the end of the case as to the medical bills, right? Because he said he has diabetes, and it goes up and it goes down, and I know what stress could do to a body, but he didn't put that in, so I'm not asking for it. I'm asking for what I know, and that's the attorney fee.
So it's licking
so
here.
I'm asking you, stop, Mr. K-Moore, stop it. Stop it. I asked you to mute yourself a long while ago.
Which I did.
You still haven't done that. You still haven't done it. Because if you did it, you could be talking, and I wouldn't be able to hear you. You wouldn't be causing the reporter to have problems recording what I'm saying if you would mute yourself. So I'm asking you, Ms. Marion, from the first day to today's date, to submit to the court by, this is all the end of October, I'll give you to the end, right before Thanksgiving. Well, I'll give you after the holiday. Give you to the end of next month, November 30th, to submit to this court and to Mr. Kaimoff a breakdown of the attorney fees. Okay? You have to submit not only that, you have to submit the retainer and then submit the breakdown of the attorney fees. And then that amount will be the amount that this court is going to order in contempt.
I don't have this amount, Your Honor. I don't know.
That is my decision. You have to order the records, and with that, I'll order it and send it to Mr. Kaimoff because he does need to have a copy of at least the order.
Your Honor.
Okay, I thank you.
Your Honor.
I thank you.
Your Honor.
Everyone have a great day.
Your Honor.
Marion, you have to get Mr. Kaimoff's email address.
Your Honor, I'd like to put it on the record.
Okay. So thank
Madam
you.
Court Reporter, could I just get your email in the chat? Order the record.
Sure. Yes, it's L. Domino. L. D as in David. I. M as in Mary. I. N as in Nancy O. at nycourts.gov.
Thank you so much.
You're welcome.
Miss.
That's November 30th, by Wednesday, November 30th, Miss Marion.
Your Honor.
Will do, Your Honor. Thank
And
you.
that goes back to the first date when Miss Caruso was in.
Your Honor.
So, not the date when the motion was filed, just the date when from when we started the hearing?
That is correct.
Okay. Got it. Will do. Thank you, Your Honor.
Your
You
Honor,
ask for interest from that date, but I just want the attorney fees from
Your Honor,
that date. Okay?
Your
Yes,
Honor,
Thank you. Be well.
Your Honor,
You too.
Your Honor, Your Honor. So I hear your mama, you boss.